also been central to our economic and, by extension, our national security success. One need only look at U.S. overmatch advantages in nuclear and electronics-enabled capabilities at critical junctures in our history to see how economic scale and technological superiority worked hand in hand in service of our global preeminence. In this connection, as this committee considers the contribution of Cepheus and export controls to U.S. national security, I would invite the committee to keep in mind two questions which may help frame the discussion. First, at this time in our history, what's the optimal balance to strike, for the U.S. to strike, between economic openness and restrictiveness in order for our country to secure the most important advantages of openness while mitigating its greatest risks? Second, whether in light of that equilibrium, Cepheus and the current export control regime is, by virtue of its resources and authorities, properly configured to effectively implement and maintain this balance. In the interest of facilitating this, I'll just offer some observations. I won't offer all of them. All of them will be in my written testimony, but just a few to start things off here. First, foreign direct investment, FDI, is critical to U.S. economic vitality. The collective economic strength and vitality of our economy, to which FDI clearly contributes, helps resource our investments in national defense and extends our soft power reach around the world. While the U.S. remains a preferred global destination for FDI, our global share of FDI has declined in recent years. Because of its many benefits, this should be concerning to U.S. policymakers, including U.S. national security policymakers. Indeed, nations today must compete for foreign direct investment. A failure to consistently attract benign FDI into the U.S. would present a long-term systemic national security risk to the United States. But while FDI is generally good, certain transactions do, in fact, present transaction-specific national security risks. The policy question to consider, therefore, is not how to balance economic and national security interests, but how to balance systemic and transaction-specific national security risks. In recent years, strategic competition between the U.S. and China has increased across multiple domains: economic, political, diplomatic, and military. And there is no reason to believe that that competition will abate in coming years. China is actively pursuing a well-resourced, coordinated science and technology strategy that seeks to bolster indigenous Chinese innovation and to position China to be the world's technology leader. A number of pillars of this strategy, as Chairman Royce rightly pointed out, have been described in various official Chinese government pronouncements, such as Made in China, a number of 5-year plans, and certain published technology roadmaps. If successful in its articulated form, this strategy would have important Chinese economic and social benefits. It would contribute to the U.S.-China and economic relationship, but it would also have deleterious impacts on U.S. national security. As a matter of legal authority, export controls apply to the transfer of specific or general types of technology to foreign persons generally. In other words, their reach is not limited by law to a prescribed set of commercial circumstances, for example, corporate transactions. The controls vary by technology type, end use, and end user, and are designed to advance one or more national security, foreign policy, or other goals. The system is highly complex and nuanced. As a matter of legal authority, Cepheus's legal jurisdiction over many, but not all, transactions. 3 things must be true for a transaction to be a covered transaction, and thus fall within Cepheus's jurisdiction. First, the buyer or the investor has to be a foreign person, the transaction must be a controlled transaction, and the target business must be a U.S. business. All of these things are terms of art, and while Cepheus' reach is broad, it is not infinite. Export controls and Cepheus have different, independently important, and complementary responsibilities. As Congress considers reforming one or both, it should focus its review primarily on gaps in resources and authorities. I will just end by saying U.S. technology leadership is essential, particularly with respect to certain emerging and foundational technologies, to long-term U.S. national security interests, To achieve this, the U.S. should pursue, and not shrink from pursuing, a whole-of-government strategy that does not rely exclusively on Cepheus and export controls, or see these areas as the exclusive vectors of national security risk, but builds strength on strength by countering illicit technology transfer, however that may occur, enhancing the U.S.'s economic competitiveness and technological superiority. Thank you again for the opportunity to be with you today and for your commitment to exploring these important issues. I look forward to the committee's questions.
Thank you, Mario. We go to Ambassador Larson.
Mr. Chairman, Mr. Engel, distinguished members, I am delivering my testimony today on my personal responsibility and not on behalf of the organization where I work, nor its clients. Nevertheless, my views have been informed by over a dozen years at Covington and Burling and 32 years at the State Department. At each organization, I had responsibilities for Cepheus, trade, controls, and sanctions. As Congress considers Cepheus reform and export control reform, including the Export Control Act.
Excuse me, Alan, here's a suggestion. Just pull the microphone a little closer to the people in the back. Indicate they couldn't hear. There you go.
Is that okay? Thank you.
Ambassador, thank you.
No. As Congress considers reform of Cepheus and export control reforms like the Export Control Act, we should remember that the United States benefits greatly from foreign investment and foreign trade. Foreign investment promotes economic dynamism, creates jobs, spurs innovation, and contributes to our ability to fund strong military and national security capabilities. In my view, Cepheus works best when it focuses narrowly on protecting national security. Certain investments that give a foreign person control over a U.S. business can have national security implications. Cepheus has been effective and adaptable in addressing such national security concerns. Other broader and vague economic goals, such as economic security, in my view, should not replace national security as the standard for Cepheus. Similarly, reciprocity or concerns about another country's trade policy, while very important issues, should be addressed by other policy tools and not by Cepheus. Congress and the executive branch should regularly review, modernize, and reform Cepheus and export controls to address emerging national security risks. In the case of Cepheus, they did so in the Foreign Investment and National Security Act of 2007. During the 10 years since FINZA was enacted, however, new security challenges have emerged. Today, China has become both an economic competitor and an economic partner of the United States. In addition, China is both a strategic competitor of the United States and, at the same time, China works with the United States to promote certain shared security objectives, including on containing the threat of North Korea's nuclear weapons and fighting terrorism. U.S. policy should reflect the complexity and importance of our relationship with China. We should avoid actions that unnecessarily feed perceptions that we believe conflict between our countries is inevitable. Now, China and the United States each have strong commercial reasons to pursue leadership in critical emerging technologies, including artificial intelligence, semiconductors, and robotics, among others. Some of these technologies have both commercial applications and also national security applications. As we consider the implications of these and other technologies on national security, we should very seriously consider reform and modernization of Cepheus in tandem with reform and modernization of U.S. export control regimes, including the EAR and ITAR. Cepheus and export control regimes can and should complement each other and be consistent with one another, not overlap and not contradict each other. Each regime in my view, should focus on its areas of core expertise. Other countries often criticize Cepheus and U.S. export controls and exaggerate their impact on legitimate commerce. My view is that the United States should do what we need to do to protect U.S. national security, notwithstanding such criticism and misunderstanding. At the same time, we should take a clear-eyed, thoughtful, and balanced approach. We should protect national security in ways that promote economic dynamism at home. We should protect national security while avoiding, to the maximum extent possible, actions that unnecessarily foment misunderstandings. The United States can and must build deeper and stronger economic and strategic cooperation with China while protecting national security. And in my opinion, we should see reform of Cepheus and of U.S. export control laws as complementary to such a clear-eyed strategy. Thank you, Mr. Chairman.
Thanks, you, Alan. Mr. Wolf.
Thank you, Chairman, Ranking Member, for holding this hearing, for introducing the bill, raising the topic. Thanks also to Senators Cornyn, Feinstein, and Congressman Pittenger for raising the issue in their bill as well. This is a very important topic, and from my time in the government, I agree that the underlying motives and concerns to be addressed by each of the bills and the topics should be addressed, and they're real and legitimate. And this has been a terrific example of a quality public debate on a very serious, difficult issue. By the way, also, the views I expressed today are my own and not on behalf of my firm or any of its clients. So I think most people agree with the underlying issue to be addressed and the concern that you described well in your opening statement. The issue is how best to address it in a way that does more good than harm. And in general, with export controls and Cepheus, there are two primary approaches that are being discussed. And one approach is a very broad, open-ended scope of controls or investment authorities that is safe, that catches large numbers of transactions, and one decides later whether there is a transaction of concern or technology to be transferred that would be of concern. And the other approach is a much more tailored, specific set of controls where the government does the hard work up front to identify what the threats are and to address the controls more directly with fewer collateral consequences, less uncertainty, and less harm to foreign direct investment. So my role, in my view, is that to the extent that any of the concerns that are being discussed in either of the bills deal with technologies of concern that are not now controlled by the export control system, but that should be, the best way to address it is through the existing export control authorities. Very simply, all of export controls can really be reduced down to one sentence. They are the set of rules that govern the export, re-export, and transfer of technology, software, services, and hardware to specific end uses, to specific destinations, and to specific end users for various national security and foreign policy purposes. That's my entire professional life in one sentence. I feel very small all of a sudden. Anyway, within the export administration regulations, there are lots of tools to address each of these issues depending upon what the threat is in very tailored ways to avoid unintended consequences and strains on government resources. The rules are capable of being adapted unilaterally and quickly for emerging technologies that are of concern that weren't identified as part of our list review efforts. They are capable of addressing specific end users, and specific destinations. The descriptions of the technology and the types of information that can be captured and controlled by these regulations is infinitely variable, going from, at its earliest stages of information, developmental technology or know-how, and leading up all the way to through production and operation and use technology. To go right to the answer to the question of this hearing, how do we best address and regulate cutting-edge technologies for national security reasons? Frankly, I think the answer is in your bill in Section 109, and it lays out a process of requiring the government through an interagency process drawing upon all the experts that are within the government and outside the government in industry and academia to identify what the threats are and what the choke point technologies and other information are to address the concerns that you well described in your opening. To publish those as drafts so that industry has a chance to review it and comment on it, to avoid unintended consequences and to make sure that it's clear and understandable. If it's an emergency situation, use the existing authorities within the export administration regulations to tag those and control those technologies immediately. But to the extent it is not an emergency, work with our interagency friends to submit to the multilateral regimes these same technologies so that our allies are controlling it as well for the same reason. To support and fund the administration of these regulations for education and outreach, and for very aggressive enforcement of the controls for a level playing field, and then have a process in place to regularly review and update the controls as threats and technologies evolve. This bill, the statutory authority for this system, was last addressed 40 years ago. The world is a very different place now than it was then, and so I applaud the members in this committee for raising this topic and moving forward. And with that, I'm happy to answer whatever thoughts or questions you might have.
Mr. Wolf, thank you. And for the committee members here, the challenge, the reason Elliot and I have introduced this bill is this new export control statute is because the Export Administration Act, which has been around for a long time, it was designed to handle trade controls on the Soviet bloc. So that was before most of the members were on this committee. And it's never been comprehensively updated since then. It's been in lapse, actually, for most of the last quarter century. And as a result, what we've done is we've had to rely on emergency authorities to uphold our dual use. And that's why we're focused on this legislation. As Mr. Wolf noted, it is key to control emerging critical technologies that may become essential to national security. The Export Control Reform Act that we've got here before us in the committee would explicitly assign this authority to U.S. export control agencies. So I'll ask Ambassador Larson first, are you concerned at all that attempting to control emerging critical technologies primarily through an expanded Cepheus process may negatively impact U.S. innovation and indirectly technology advantage?
Well, thank you, Mr. Chairman. I think that one of the things I learned in government was that we were usually most effective if we had the parts of our government that had the expertise and the knowledge to lead. And so in respect of controlling the export or transfer of critical U.S. technologies, my first point of emphasis would be on the export control regimes that we've used in the past. I support the idea that those need to be updated to take into account the changed geopolitical situation, the changed technological situation, but I think that's the first way to start. I think Cepheus does a good job on its mandate, and its mandate has been to ensure that there are not acquisitions by a foreign person of control of a U.S. company that would impair the national security. And that can include instances where that U.S. company has critical technology. So, and I think Cepheus has handled that responsibility well.
I think they're complementary, but I think we've got to have export controls
Precisely.
in statute, and that's what we're focused on.
Precisely.
So here's another question, and I'll ask this one of Mr. Mancuso or Mr. Wolf. If one of the most pressing concerns driving this debate is technology transfer to China, could U.S. export controls be tailored to address this national security concern without excessively impacting trade with other countries, or without creating undue uncertainty about whether other transactions could come within the scope of Cepheus review? Mr. Wolf, if you'd like to start.
Yes, absolutely. That's my primary point about the beauty of the export control system, in that it is infinitely tailorable to address specific technologies at whatever stage of their concern, at whatever stage of their development that are of concern, for transfer to specific end users or specific destinations or for specific applications. And that way, once you identify what the threat, once the national security experts identify what the concerns are that would harm our national security in terms of altering our edge on a variety of different areas, you can, through the export control system, either unilaterally or multilaterally or both, identify those technologies specifically and clearly and tailor them in such a way so that it doesn't affect the types of transactions or countries or end users which are not a threat, particularly with respect to the allies. To the extent that the concern is not related to technology transfer, then the export control system may not be your best vehicle, and other tools such as the espionage rules or the IP theft rules or Cepheus for other topics should come into play. But I agree with the essence of your question completely.
And Mario, do you concur?
So, Chairman Royce, I do concur, but I'd like to add some additional detail because I certainly think that the export control regime has the existing authority, has built within it the capacity to be flexible and fast and all the things that Kevin mentioned. But I would point out that as a practical matter, in the execution of these responsibilities, the system operates very differently today. So, for example, even the taxonomy of creating SIFs between destination, end user, and end use kind of suggests the Cold War and 9/11 era thinking around export controls and products outside the United States. I think the fact of the matter is that for some of these emerging technologies, that transfer is occurring within the United States. So while I agree the authorities are broad enough, I'm not sure the resources are there or the practice sufficiently developed that we focus on illicit tech transfer inside the United States, because I think that's critical, and that's fundamentally different than the Cold War. One other point, Chairman Royce, if I may. The other thing that's difficult is during the Cold War, you know, our U.S., there was tremendous agreement with U.S. strategic allies about the Cold War threat. And at the time, our strategic allies were not our economic competitors. Today, they are both strategic allies, and we're thankful for them, but they also happen to compete with us globally. And so we just have to keep in mind that the context is a little different, even though the authorities are robust.
Thank you, Mr. Mancuso. Here's one more question for you. So we've had 30 years time frame here. We've had a number of U.S. presidents, but they've only blocked a total of 5 Cepheus transactions, 2 of which happened under this administration here recently. So given the news yesterday about the White House stopping what would have been the largest deal in tech history, is it fair to conclude that the Cepheus process is evolving toward a stricter review process irrespective of potential legislation here by Congress?
I will take that question first. I'm not going to comment on that specific transaction, but I'll just comment on the fact that 2
Yeah, I
transactions—
remember your caveat coming into the testimony
that
here.
2
Yeah.
transactions have been blocked in really as many years, right? Actually, now 3.
Right.
I think, frankly, the FIRMA bill largely, but not completely, would implement current agency practice with Cepheus. Okay. And you can quibble about whether or not Cepheus is acting beyond its current authorities, but I think it would largely implement that. But I do think the blocking of the transactions suggests that the United States government, the executive branch, is taking these issues seriously, perhaps in a blunt way, but is taking these issues more seriously. And I think that the U.S. government needs to take these issues more seriously.
Thank you. And Mr. Wolf, you wanted to comment on that.
So just to follow up and to repeat, the key with all of this is to spend the time and the resources and to have the creativity to identify those emerging technologies of concern that aren't normally looked at in the traditional export control system, which we're used to in terms of weapons of mass destruction or traditional military items. And for this effort to succeed and the FIRMA effort to succeed and the policy objectives in both to be achieved, I agree. What really needs to be spent is a lot of very clever thinking, the addition of new resources to the existing system to reach outside the box, to identify what those technologies are that are not now controlled but are emerging but should be, and to list them and regulate them to the end users and end users of concern. With respect to the Cepheus question you ask, it all goes down to the deliberate non-definition of national security. National security evolves, it changes, the legislation, either the current bill and the existing statute does not define what that means. It's up to those in charge in order to apply their discretion to what the threat is today. I believe that the Cepheus system today and before is adequately addressing those and not approving transactions that would leave unresolved national security concerns. So there can be a guide to what national security means, but trying to restrict it or identify or specifically tailor it, I don't think would be a good idea because threats and issues evolve.
Thank you, Mr. Wolf. I appreciate it. Mr. Engel, Ranking Member.
Thank you, Mr. Chairman. I was happy to join with you a few weeks ago in introducing the Export Control Reform Act in a bipartisan way, and to me that's been a hallmark, as we have said so many times, of the way this committee operates in a bipartisan way. Wish that more of the committees in this Congress would operate that way, but I'm very pleased that we do. I'm pleased we're following up with this hearing, which will help bring members of the committee up to date on our system for controlling the export of dual-use goods and technology, and it isn't something, obviously, we talk about a lot, but oversight of the export of dual-use items, that is, items that have both military and commercial applications, is an important part of our committee's jurisdiction. In my view, it's just as important as our work regulating the export of military items. A few decades ago, the defense sector nearly always drove the development of high-tech, which later ended up in the commercial sector, and today the opposite is often quite true. High-tech in the commercial sector is now often the precursor of advanced weapons. So your bill, Mr. Chairman, will help us take a fresh look at our export control system to bring it up to date with the modern reality of the way these technologies are developed and sold, and it would give us an updated charter that grapples with the global risks of sensitive technology falling into the hands of our adversaries. So this update is long overdue. As was mentioned, previous law was last revised in 1979 in the depths of the Cold War, and it's replete with out-of-date provisions that don't reflect national security's provisions today. It also expired in 2001, and it means the authority for granting export licenses is no longer based in statute, but relies on temporary emergency authority that is now nearly 2 decades old. Last year, some 34,000 licenses were processed for exports of sensitive technology, and if you ask me, this isn't something we ought to be doing willy-nilly. We need a sound, updated, and permanent statute, and that's why, Mr. Chairman, I was so happy and proud to join with you on this. Let me ask Mr. Wolf and Mr. Mancuso first. Each of you managed the export control system while it was under temporary emergency authority and while it was under legal challenge. So I'd like to get you on record. Would you agree that it would be better to have a sound, permanent statutory authority for the system?
Absolutely, Mr. Engel, and I'd go further and say that I think the U.S.'s whole-of-government strategy should be built around export controls, not built around Cepheus.
Thank you, Mr. Wolf.
While the existing IEPA authority is sufficient legal authority for the existing regulations and enforcement thereunder, I'm not denying that. I agree with you that having permanent legal authority in the form of this or a similar bill is very important for a variety of reasons, and also to express the will of Congress with respect to a very different world that exists now than existed in 1979. So I agree with the point of your question.
Thank you, and let me ask you another one, Mr. Wolf and Mr. Mancuso. And last year, the Export Control Bureau at Commerce and its partners at DOD and State processed 34,000 licenses, and the trend will continue to be upward. Are the government's resources adequate to handle that volume and make good decisions? I'll start with Mr. Mancuso.
So just like any enterprise, the government can't do everything everywhere all the time. The number of those licenses, I think BIS has historically been under strain. I'll defer to Kevin on his recent experience. I served for President Bush in that role. But I think as a general proposition, yes, my recollection is that the Bureau needs more resources, but I don't think of resources only in terms of financial resources. I actually think injecting the Bureau of Industry and Security with additional national security acumen and additional connectivity with the rest of the government is important. I'm not suggesting that isn't there. I just think that as an agency that's embedded within a cabinet department whose principal clients, if you will, are broader commerce, I think it's imperative for that agency to remain connected with its national security and foreign policy colleagues to effectively carry out its mandate. So resources are both financial, would be important, but also in terms of enhanced capability and connectivity with the national security enterprise of the United States.
Thank you. Mr. Wolf?
It's great no longer being in government because I can answer your question without being limited to instructions to stick to the budget given. And it's, yes, absolutely. It's for enforcement both in the United States and outside the United States are critical, and the authorities to do it in order to keep the level playing field and to deter those who would violate the regs. For more industry education and outreach, particularly to small and medium-sized businesses, I think would be critical. And then going to the point of this hearing, more resources in terms of both money and personnel, but creative thinking to identify the types of emerging technologies that aren't traditionally part of the export control system, and working with people that aren't traditionally part of the export control world to identify those threats that are novel and not previously considered. And then with respect to resources, that then leads to what I would advocate and always wanted to do on the dual use side, which is frankly a top to bottom list review effort of everything in the very long list of controlled items to see what's there that no longer needs to be in light of evolving technologies, and going back to the emerging point, what isn't there but should be. And that just requires a substantial multi-year effort, working with industry, working with experts in the Defense Department largely and other parts of the government to figure that out, as opposed to the sort of regular process that exists today, which is adequate and good, but I think it should be a lot more robust and aggressive.
Thank you. And Ambassador Lawson, I have one quick one for you. Given your experience at State, are the budget and staff cutbacks that we're seeing at State having a negative effect on the department?
My judgment, I haven't worked there for 12 years, but my judgment is that it's very hard for the State Department to do the missions that it's been asked to do with such tight budget situation. Certainly in the areas I was responsible for in economics, I think that's true.
Thank you. Thank you, Mr. Chairman.
Thank you, Mr. Engel. We go to Mr. Chris Smith in New Jersey.
Thank you very much, Mr. Chairman. I want to thank our witnesses for their insight and recommendations. Mr. Chairman, I'm very concerned by reports that U.S. companies are selling equipment and technology being used by the Chinese government and its ubiquitous surveillance and detention program, including the targeting of Uyghur Muslim ethnic minority persons in Western China. Some estimates suggest that something like 500,000, some put it much higher, Uyghurs are being detained in political education centers, which are really just detention centers. This is a staggering figure. Included in the crackdown are family members of Voice of America, Uyghur language broadcasters. Chinese police are gathering and storing DNA samples, fingerprints, iris scans, and blood types, and other biometric data from all Uyghurs between the ages of 12 and 65. Human Rights Watch identified a Massachusetts-based company, Thermo Fisher Scientific, as supplying the Chinese government with DNA sequencers. Other companies are providing surveillance cameras or software for facial recognition equipment. Would you say that United States law bars U.S. companies from exporting technology that aids in the crackdown of the Uyghurs? To me, that would seem clear, the clear intent of the 1978 amendment to Section 502B of the Foreign Assistance Act of 1961, which states that export licenses may not be issued under the Export Administration Act of '69 for the export of crime control and detection instruments and equipment to a country, the government of which engages in a consistent pattern of gross violations of internationally recognized human rights, unless the President certifies in writing to the Speaker of the House and the Chairman of the Committee on Foreign Affairs and the Senate Foreign Relations that extraordinary circumstances exist warranting provision of such assistance and the issuance of such a license. We've checked with the House Foreign Affairs Committee and Speaker's office, and neither have received waivers for the sale of detection and surveillance equipment to China. So the question again is are companies allowed to export that, especially now that we know that's being used, especially against the Uyghurs? Are you aware of any companies selling equipment and technology that China is using for its massive police state surveillance efforts? And how can U.S. companies sell technology and equipment that is being used for these purposes? Is that a problem that the Commerce and the State Department are not policing this area very well? Is it a matter of negligence? Or is the problem with the law, and does that law have to be rewritten in a world where DNA sequencers, biometric data gathering, and the use of artificial intelligence for surveillance is now becoming commonplace? Ambassador.
Well, thank you, Mr. Smith. I would like to defer to the two colleagues who actually ran export controls.
That's great.
Yeah.
Sure. So most of this discussion today is about national security controls, but foreign policy controls, crime controls, which include human rights issues that you raised, are very much part of.
If I can interrupt, I
Yes.
would always say that human rights violations, particularly on such a massive scale, absolutely rise to the level of a national security interest
Okay.
of the United States.
Fair point, fair point. I often, but in any event, it covers both, either national security, foreign policy, human rights, however defined. And the key to the point of your question is with respect to the technology, and I don't know the facts involved, is whether the items of concern are listed on the Commerce Control List. And there are long lists of items that are controlled for crime control, CC reasons, such as fingerprint equipment and things like that, that are controlled for exactly the reasons that you just described. With respect to the facts that you're dealing with, the question would be whether they are on the list now, and if not, should they be, or if there are reasons for they're not. Again, I don't know, but that would be the question to ask and to work with BIS. And even to the extent that it's not the equipment at issue, but the act of the foreign parties that are of national security or foreign policy concern, then BIS and the EAR have the authority to list particular entities, which could result in the prohibition on the export of any items, coffee cups, biometric equipment, et cetera, for the sake of exerting pressure on companies outside the U.S. or entities from engaging in bad acts. And that's called the entity list process, and it's a tool that BIS has to address issues such as along the lines of you described, to the extent that listing the equipment for control would not achieve the objectives sought.
Thank you.
Congressman Smith, my experience at BIS has been, somewhat dated, but I'll answer your question. The authority exists to stop those kinds of items. In the last decade, of course, the technology, I believe in this area in particular, has really developed. But during my time at BIS, we took this very seriously. Some of those items we, in fact, interdicted. But some of these items were essentially dual use, so we did not. But I agree with the premise of your question, which is that this is an area that the export control regime should look at and consider against U.S. policy objectives. So the legal authority is there, and it's a policy question about whether it's done on any given basis.
Thank you so much.
Thank you.
Thank you, Mr. Chairman.
Thank you, Mr. Brad Sherman of California.
As others have noticed, we're operating for the last quarter century under an expired dual-use export statute, the Export Administration Act. Its regulations are kept in force under IEPA. This is not regular order. This is not the rule of law as it is supposed to be carried out. It has worked, more or less. This is a critical area of jurisdiction for this committee, and we've allowed the executive branch to run the policy. That's why we've got to change that, of course, so that's why I commend Chairman Royce and Ranking Member Engel for introducing 5054, it's H.R. 5054, to update the statute in this area. This is not the first attempt. There have been many attempts over the years. About a decade ago, we faced a bit of a crisis because DTTC and the State Department was taking many, many months and to process applications, and was tens of thousands of applications were languishing. Pressure by this committee and the subcommittee that the chairman chaired, and then I chaired, and then he chaired again, at least pushed the administration to solve that problem. major effect of legislation in this area was to move satellites from the munitions list back to onto the commerce list. There are many who believe that the maximum national security can be achieved by putting the maximum controls on the maximum number of items. This may not be the case. When we don't export goods, we weaken our industrial base, setting back the money that's available to develop the weapons and technologies of the future. When we don't sell something, the buyer goes somewhere else and strengthens the industrial base of a country willing to sell to them and perhaps willing to sell to an even worse country. So I've been a proponent of having a taller fence around a smaller field. And that is to figure out what we're going to control and control it very well. I should point out that China blames our technology controls for the enormous trade deficit. That is just their attempt to lie about the real reasons for the enormous trade deficit. Let's see. One area I'd like to address to the witnesses, believe it or not, I have a question in here, which is new for me, is should we make the decisions based, especially at the Commerce Committee, well, does Commerce look at the impacts that the technology transfer will have, not just on the narrow security issue of whether that particular item will be misused in a way that hurts our security, but from an employment standpoint, from an industrial base standpoint, do we take a look at how the transfer of that technology will lead to the outsourcing of whole areas of production? So, Ambassador, I'll start with you. Does Commerce take a look at the industrial base and especially the jobs issues?
Thank you, Mr. Sherman. If I may, because my expertise doesn't lie primarily in the Commerce Department, I'd
Then
like
I'll
to
go to
answer
Mr. Wolf.
the question
Sure.
in a broader frame.
Go ahead.
Is that all right, or shall I just turn?
Why don't we go to the people who answered in a narrow way?
Sure. I'm not of the view of those who subscribe to there should be a balance between national security and jobs or economic security. National security is paramount, and all decisions are to
Yeah, I'm
regulate.
asking here, are there times where we should say no, not because that one item
Right.
could hurt our national security, but because the export of that particular technology will allow a competitor to enter a whole new field that previously had been dependent on U.S. technology? I'm not saying say yes to create jobs. I'm saying there are times we should say no to protect jobs.
That variable is not a factor in what the Commerce Department considers when deciding whether to approve or deny an individual license. It's if that technology would create a national security threat, you approve or you deny it or mitigate it.
So if there's a crown jewel that supports tens of thousands of jobs in America because we have that technology, Commerce may allow it to be exported. Mr. Manusco.
So Congressman Sherman, I would take the approach, no, we wouldn't, because we don't balance national security against jobs. We certainly balance
I think you're making the same mistake on the question.
No, actually,
do we say no, you can't export that item, even it may be consistent with national security, but because the export of that item means a whole industry is being exported?
I think it's important to keep in mind the two risks you identified, the transaction risk and systemic risk, this industrial base issue. I think with respect to certain crown jewels where the actual law, national security loss in any given transaction, an export of the crown jewel, to use your example, well, I would take the position we don't balance that. If it's a crown jewel, it's a crown jewel. On the other hand, we have to be very discerning about what is a crown jewel, because there are many technologies that might be sensitive but are not crown jewels. And with respect to those, economies of scale matter. Lower grade semiconductors are a good example of why we export them around the world and why it's important to export those around the world, because the U.S. has an interest in protecting crown jewels, but has no interest in creating protected foreign markets.
I've gone over time. I yield back.
Has no interest in creating protected foreign markets if it's not advancing a U.S. national security interest.
We go to Mr. Ted Yoho of Florida.
Thank you, Mr. Chairman, and I appreciate you guys being here. I could sit here all day and talk to you guys about this stuff because I think it's so important. Mr. Mancuso, you brought up U.S. government should build its policies around export controls, not Cepheus. Did I hear that right?
Yes, and what I meant by that, Congressman, is that export controls is a big piece. Obviously, Cepheus plays a very important role, but we have to think of
That's what I want to.
complementary.
They need. That can't be.
They can't be separate. It's not and or.
It's got to be
both.
together. You know, we were talking about intellectual properties, and we just came back from a trip to Thailand, and they were talking about the Special 301 report on IPRs and how Thailand's on the watch list, but they're doing the things necessary to make sure that they protect our IPRs of our entrepreneurs. We're talking about intellectual property, and it seems to rotate more around national security interests or the Broadcom, Qualcomm deal that the President stepped in. And as Chairman Royce brought up, the current administration did step in twice of the 5 times that were done in a period of years. And if you have an aggressive executive office, that's well, but we need to make sure that the rules are in place. And I bring up, it's not just the intellectual property on a national security or with semiconductors or things like that. I was in a meeting yesterday where our researchers from our land grants were working with biogenomes with plants. And he says, I'm an adjunct professor in China because they pay me 3 times what I'm paying here. And what they're doing is they're taking our intellectual property and research and development in the ag science fields, taking them over there, and it's not benefiting us. They're benefiting from our beginning research. And I think this, too, is something that should be looked at differently than we do now. And we've seen this over and over again. We saw the story up in Iowa where the Chinese operatives were stealing GMO corn, taking it over there. And again, it's a competitive advantage that they will get over us. So with that, is anybody looking at like the biosciences? And with that, I want to just, before you answer that, the Chinese government plans to pour $9 billion into the National Precision Medicine Initiative before 2030. That's a lot of money, and it's similar. The U.S. has only put in $215 million to their $9 billion. And it's clear that they're going to get the competitive advantage. And then one has to wonder, why is China building such a large pool? Right now they have 30% of the world's genomics that they control. And I can see this as a weapon in the future. You know, when you can start manipulating genes against the population, and we've had our medical researchers say that they'll start drug trials. They run out of money here. China picks it up and finishes it. So this drug that we put the initial research into, it gets developed with an Asian population, and it may not work the same in a Western population. And so are we looking at those as strong as we are on radars and semiconductors in your experience? And that's for all of you.
So Congressman, I would distinguish, so export controls in Cepheus are complementary, but there are only 2 instruments we have to counter some of the things. So things like industrial espionage, you know, frankly, the purposeful stealing of technologies, export controls is likely not going to catch. We need other instruments for that, and other parts of the government have been working on that. I can't tell you that my information is up to date, how those what the progress of those efforts are, but if the premise of your question that we should be watching that is what, if that's what it is, I agree with it. So that's when I.
Well, let me narrow that down. Sure. Do we have the controls in place now to protect all the sciences that we're doing, or are we mainly just focused on the telecommunications and the semiconductors?
This goes to, and then I'll pass it over to Kevin. We have the authorities to control all of that. The government as a whole needs to, and regularly does, discuss views about what technology should be controlled, but whether those specific technologies are controlled. Certainly some radars are controlled, certainly some therapies are controlled, but I'm not quite sure if all of them, at least the ones that you're thinking about,
I think that's something we need to weigh in. And you brought up, countries, not individuals, today are spying. And they've always done that, and they're always going to do that. But what we're seeing is a different geopolitics today than we had 15, 20 years ago. We have a very aggressive China going after things by hook and crook. And, you know, it's not just the individual out there doing the espionage, it's a country. And that country is taking that stuff from us. Mr. Wolf, if you weigh in 5 seconds.
Export controls are not the solution to all those issues. They're not good for industrial policy. They're not good for economic espionage or IP theft or funding issues or R&D advantages. So all of those things that you mentioned are very important, but the EAR, the Export Administration Regulations, are probably not the best place to try to address them, given the national security and foreign policy focus of them.
I thank you for your time, and I'd like to follow up with you later.
Sure.
Thank you, Mr. Chairman.
Thank you. Thank you, Mr. Yoho. We go now to Mr. Albio Series of New Jersey.
Thank you, Mr. Chairman, and thank you for the members, the panel that's here today. And I just want to follow up on my good friend from Florida on some of the things that he said. I know the title of this hearing today, but I really want to get it down to basics so I can understand some things. First thing, I remember a few years ago with solar panels, we developed the panels, energy, China gets it, and then they dump the solar panels on us. I represent New Jersey. I constantly hear from the pharmaceutical industry how Canada dumps things in America, some of the things that we develop here. Now we have India. Now South America is getting into the act. I know that I keep hearing that we have the authority to control these things, these imports. How does that happen? How do we develop the energy, the solar panel energy, goes away from here, comes back here? Don't we have any kind of control on that stuff? And how do we develop these medicines in the pharmaceutical industry? And we have places like Canada, which is supposed to be our best trading partner, dump the stuff here. I mean, to me, I'm missing something. And I know, Mr. Wolf, I hear you going back and forth. Sometimes you talk too fast for me. Maybe I'm stupid this morning, but, you know, I just like to get some sort of a response.
You want to talk about trade remedies?
Well, I thought, yeah, Congressman, maybe I could begin to address some of your very good questions. You know, I think all of us have emphasized the fact that we need to use a multiplicity of tools. We can't just use one tool. Cepheus has a role to play. The Export Administration Act and the new legislation that's been introduced has a role to play on export controls. A lot of the problems that you're raising are ones that have to be addressed through traditional trade policy measures, things that are led by the U.S. Trade Representative's Office, but where the White House, State Department, Commerce Department play important roles. Now, you know, solar panels, there's been a decision that's been taken under the authority of Section 201 of the Trade Act. Some of the issues related to pharmaceutical products also have been a key concern. We heard earlier about some of the concerns about intellectual property theft in Thailand and measures to get Thailand to do a better job of protecting against those things. There is a very focused effort, very quickly, on China and the Section 301 investigation that is currently underway to address those practices. So those are other tools that will address some of the concerns that you're talking about, sir.
I just don't know if we have the ability to get some of these countries to stop doing these things. I mean, what controls do we have? I mean, Thailand, for example, they don't have much of an economy. I mean, do we want them to stop? How do we do that? I'm sorry, Mr. Mancuso.
You know, so I actually think it's, you know, Congressman, it's a very good question. The U.S. government has, you know, different agencies that have those responsibilities. I think the world in which we live, I mean, there are lots of problems that we can talk Thailand, we can talk China, but and I think they're all different. The U.S. government has the capability and has the authority to do those things. But with respect to certain both economic partners and strategic competitors like China, I think our game has to be better. It has to be more coordinated. And so it's a legitimate question for Congress to ask in a specific way, vis-a-vis this threat, are we configured, are we resourced to address this threat? Those are important questions to ask. I wish I had better answers. We can do it. I'm not sure we're doing it well against the numbers, the various threats that we're
Can somebody address the pharmaceutical industry? Because that is very important to my state.
Yes, but not in the Export Administration regulations. The subject of this bill and the regulations at issue couldn't solve your problem, but many other areas,
Well,
law
I didn't
201,
think those would solve
301.
the problem this
Yeah.
morning.
No, I mean, it's a legitimate issue, but it's not the subject or capable of being addressed by the Export Administration regulations, which are focused on more traditional national security and foreign policy issues of a threat as opposed to the economic considerations at issue behind your question. These regulations don't get to that
Right,
point.
I get it, but
Okay.
do you have any regulations that get to it? Not you. How about it?
Well, I think the key.
I'm specifically talking about Canada and the United States. Let me put it this way.
Well, and so on Canada and the United States, I think you've raised an issue that must be at the heart of the NAFTA renegotiations that are underway right now. And certainly the broad question of protection of intellectual property rights of companies like pharmaceutical companies that invest billions of dollars in developing new products lie at the heart of most of the trade negotiations that USTR leads on behalf of our government.
Well, I just want to thank you. Thank you, Chairman, for that.
Thank you for the questions. Next, we'll go to Ann Wagner from Missouri.
Thank you, Mr. Chairman, for hosting this important hearing. This issue is important to my district as China has been looking to expand its footprint in the Midwest. Representatives from the Chinese consulate in Chicago spent the past year networking with Midwestern government offices, including a stop in my district office. And they stated that, and I quote, "Suspicion of Chinese foreign direct investment and excessive national security reviews would be bad for the bilateral relationship." However, I was quick to remind them that failing to properly control our exports would be bad for America. I am committed to working with the committee to reevaluate our export control regime to ensure that it is up to the challenge, and I thank you. Mr. Mancuso, I appreciate your insights on the Foreign Investment Risk Review Modernization Act, or FIRMA. You noted that the bill encourages heightened engagement with our allies. The more closely we coordinate with foreign partners, the better our own export control regime will work. There is an opportunity here to expand the list of countries that participate in multilateral export control regimes, especially in Asia. For example, the U.S. has strong ties with Singapore and Malaysia, which have struggled to prevent controlled goods from making their way into North Korea and China. What, sir, can Congress do to help these countries become productive partners in our export control system?
Good morning, Congresswoman. So I'll do my best to answer that question. First things first, I do think international trade and investment, foreign direct investment, in most cases is overwhelmingly positive, including with respect to China. But I think we have to be very sober about those areas where it's not. This is true for foreign investment. This is true for tech transfer, export controls. In terms of the things our government should do with respect to our partners and allies around the world, I would distinguish between treaty partners and treaty allies and partners. They're all important. We value their relationships. They all contribute something. But treaty allies, I think, are special. With respect to those, I think the United States should engage in this kind of diplomacy to ensure that our colleagues understand our perspective. They may disagree, and they're entitled to disagree. They're sovereign nations. But they should understand our perspective of why technology transfer is important and why the regulation of certain foreign investment is important. I would just point out in response to that some of our NATO allies are now considering either implementing or upgrading their Cepheus-like regimes. I think if done well, that is a good thing. I think it is in the U.S. interest that our treaty partners have resilient economies, and they have economies that support their national security interests as well, which tend to coincide with ours.
Both the United States and China are deeply aware that economic and national security can't be separated, as we've stated here today at the hearing. Ambassador Larson, I'm curious about how China might respond to FIRMA. Can you give us a status update on Beijing's foreign investment law? Also, what might the Chinese version of Cepheus look like, and how would it affect our bilateral relationship?
Well, thank you for the question. First of all, I've had a lot of conversations with Chinese when I was in government and the role I have now, and the complaints about Cepheus and about export controls are sort of a persistent theme. And I've been a very strong defender, actually, that the way that our government in the United States has implemented Cepheus has been very targeted and has focused on those transactions that could present a threat to national security. And I will continue to take that position, and I think that should be a position that will be embodied in the reforms that are contemplated in FIRMA. China does have a national security law that affects investment in China right now. I don't think it is implemented in as sophisticated a way as Cepheus is administered. I think that I think that it will be important when some of our Western allies implement national security-based investment laws as well, because I think having a relatively common approach, whether it's on export controls or on inward investment controls, is a strong point for us. When we can do that with our major allies, that's important. I think we're just going to have a very candid set of conversations with China that start from the point that we understand that two-way investment is good for both of our economies. We understand that we do depend on each other's economies, but we will take the steps that we need to take to ensure that investment is not permitted, or acquisitions are not permitted that impair our national security. So I think it's a time where very candid conversations with China on the nature of our economic relationship, trade and investment, are going to be required to work out the problems that we have in the relationship.
Thank you very much. My time has expired, Mr. Chairman. I will submit the rest of my questions for the record. Thank you.
I thank the gentlelady. Tom Garrett of Virginia.
Thank you, Mr. Chairman, and I would tip my hat in his absence to Senator Cornyn for working on this important legislation, and on to the chairman and ranking member of this committee. And I would point to a quote from someone I don't quote that often, Vladimir Lenin, who said, "We will hang the capitalists with the rope that they sell us." And I would submit that anecdotally, as a young Army officer, I heard a story of Q-36 and Q-37 firefighter radars finding their way to China during the Clinton administration, only to have American military warrant officers sent to help the Chinese put them back together, I presume to reverse engineer them, and those of us who knew what that counter-battery radar allowed us to do wondered how the hell they got to China. Now, it's anecdotal, it's hearsay, as I would say in a later career, but I know this stuff happens. It blows my mind. The Gen 3 GPS signals were given to our enemies under President Clinton and have literally been used, at the very least, to take the lives of our allies. And I understand that there was much made about the transfer from the NTIA to ICANN of controls over the internet, and some of it was hyperbolic and overstated, but some of it wasn't, and I wonder what the heck we're doing. So let me ask about FIRMA and Cepheus as it relates to EB-5 visas. Would the FIRMA Act extend into the realm of the granting of EB-5 visas? Mr. Mancuso.
Congressman, I don't think so. I'd be surprised if they would.
Does anybody
I
at
don't
this
know.
table believe that that's not the case? I believe that that's the case, that you're correct.
It does not, but in the export control system, there are prohibitions on what are called deemed exports, which are the release to technologies to foreign persons in the United States, regardless of the visa or other reason they're
All right, Mr. Wolf, with all due respect, and I mean that.
Yeah.
I got a finite amount of time.
Okay,
But so it
so
doesn't.
no, but yes.
And so might it make sense to extend some sort of congressional oversight and review to the EB-5 visa issuance process, Mr. Larson?
I think that Congress can and should look at all things that it thinks could be important.
And do you think it could be important to make sure that we're giving EB-5 visas to the right people who might not have dual-source technology at their fingertips by virtue of a permanent residence in the United States and a business that essentially manufactures what might be sensitive technology? Yes or no, please?
If I were in the State Department, I would not want to give a visa to someone that was coming to the United States for the purpose of stealing technology.
So when the Washington Post, noted conservative-leaning paper, right, that's tongue-in-cheek, says that Virginia Governor Terry McAuliffe garnered special privilege in receiving EB-5 visas through the Department of Homeland Security under the Obama administration, we know that he lined his pockets. We know that Green Tech Automotive is now defunct and that the taxpayers of the state of Mississippi have lost millions of dollars. But to the extent that things like lithium-ion batteries, which is undergirded by the Chinese monopolization of the global cobalt markets, et cetera, can have dual uses, would not selling citizenship or permanent residence to the United States potentially compromise technology that might be that proverbial rope that Lenin says they will buy from us to use to hang us, Mr. Mancuso?
The answer is that's, let me answer this differently. I don't think we should, I think citizenship is special. Citizenship goes to how you feel about your country and your commitment to your country. This is an existing program. I think it's certainly something that this Congress could look at as part of a broader view of how we think about the U.S.'s engagement with the rest of the world.
Again, sincerely, thank you all for being here. I intend absolutely no disrespect. I have a finite amount of time. EB-5 visas grant not citizenship but permanent residence under green card status for people who invest $500,000 in undeveloped areas or $1 million in developed areas of the United States to engage in the discourse of commerce. However, in 2014, I believe we granted just over 10,000 EB-5 visas. I'm not that good at math, but 85% of them, or north of 8,500, were to Chinese nationals to engage in commerce on American soil, wherein I would presume they would have lower barriers to entry as it related to obtaining technology that might have dual uses. Mr. Wolf, you're nodding.
Yes, I agree you have a legitimate issue with that exact point for that reason. Just because they become a citizen through that process, that their motives with respect to acquisition of dual-use technology should be part of the process.
And so that's something that you gentlemen would concur, and again, I'm out of time, but I'm going to ask real quickly, Mr. Chair, that we might ought to review as well in conjunction with Cepheus and the actual sending overseas of technology itself.
Absolutely.
Thank you. Thank you, Mr. Chairman.
Thank you very much, Tom. Let me just conclude our hearing here by thanking all three of our members of this panel for coming and testifying, and also for giving us your insights on the pending legislation. And if none of you would mind, we'll, of course, have some additional questions as we move forward. So thank you very much, and we stand adjourned.
Thank you.
Yeah.
I was totally not trying to be rude to you guys.
It does go fast.
Hope we can move this bill. Thank you, Mr. Chairman. I think we can. I don't see any opposition to it.
Mr. Garrett's issue is the judiciary. Yeah, thank you, Mr. Chairman. You're right.
Yeah. Mario, thank you.
Thanks a lot.
Look, I appreciate your time here, and any thoughts that you have, you could share them with James.